Hello and welcome to the 25th Annual George Mason Law Review Antitrust Symposium, celebrating 25 years of antitrust. My name is Carly Vieding, and I am the Symposium Editor of the George Mason Law Review. This event is brought to you by the George Mason Law Review and the Global Antitrust Institute, and is sponsored by Freshfields and CRA. Thank you for joining our panel, Potential Competition and Nascent Competitors. Our moderator is Professor John Yoon, Deputy Executive Director of the Global Antitrust Institute and Associate Professor of Law at George Mason University, Antonin Scalia Law School. Professor Yoon?
Thank you, Carly, and thank you to everyone at the Law Review, as well as the staff at the Global Antitrust Institute. Welcome back to the 25th Annual George Mason Law Review Antitrust Symposium. As Carly mentioned, my name is John Yoon. This panel is Potential Competition Nascent Competitors, and let me introduce our panelists. First, we have Julie Elmer, who is the U.S. Head of Antitrust Competition and Trade Group at Freshfields Bruckhaus Deringer. We have Scott Hemphill, the Moses H. Grossman Professor of Law at New York University School of Law. We have Jonathan Jacobson, who is a partner, Antitrust and Competition at Wilson Sonsini, Goodrich, Rosati. And we have Geoffrey Manne, who is the president and founder of the International Center of Law and Economics, the ICLE. So we have an action-packed panel. I'm genuinely thrilled and honored to be the moderator of this distinguished group. And so we're going to jump right in, and the audience can give some Q&A, and I apologize ahead of time if I'm not going to be able to get to all the questions the audience may have. So let me start with Jonathan. Jonathan, is there a difference conceptually and legally between the doctrines of potential and nascent competition, even though these terms are often used interchangeably?
So I don't really think so. Now, you have a very useful separation of the two in the paper, where you describe nascent competition as basically a product or technology that could eventually compete in the market. And you distinguish that from straightforward product line extensions or geographic market extensions, which you would put in the category of potential competition. But to me, that distinction, and I know Scott has made some distinctions in print as well, that distinction really doesn't capture the impact on competition of an acquisition of a nascent or potential competitor. The issue in each case is the acquisition of this company, be it potential or nascent, going to materially inhibit competition going forward? And that can be true or not true for both nascent and potential competitors. The issue at the end of the day is there some possibility or reasonable probability, and we'll get into the distinction between the two, that but for the acquisition, this company would have emerged and created additional and significant competition in the marketplace. Now, Marine Bank and prior Supreme Court decisions have made that a difficult challenge. And one of the things I'm sure that we'll be talking about today is whether potential competition or nascent competition doctrine should be modified to reach more deeply into acquisitions such as these. But because the issue is really the same in each case, is the acquisition of this company going to be harmful? I really don't think we should be spending a lot of time on precise distinctions between potential and nascent. And I'd go back to one of my old cases, one that I lost, SCM against Xerox, where the issue was, is the Xerox, their xerography technology going to dominate the copying industry? And the Second Circuit held that because the relevant market had not emerged at the time, that acquisition was lawful. I think we would have a different lens on acquisitions of that sort today. But the Battelle Memorial Institute, the company that Xerox took the patents from, was clearly not a potential competitor under the accepted definition, but it was a source of nascent technology competition. And although the Second Circuit disagreed, I think the impact of that acquisition was strongly anti-competitive, but the decision really put a crimp in analyzing and challenging those acquisitions going forward. So anyway, that's my take on this.
Thank you, Jonathan. And you mentioned the difficulty in bringing these types of cases given Marine Bancorp and prior precedents. So this actually leads me to a question for Scott. Scott, you've written a number of important pieces in this area. And so, what guidance, given your research and your scholarship, would you give to agencies to bring these types of cases, these nascent competition cases, and where firms do have significant market power in acquiring smaller firms? What are the guideposts? What should we be looking for?
Yeah, sure. So first, thanks to the organizers for bringing us together. This is a great group who I've learned from in a lot of other contexts, so it's fun to get to talk about these issues. I should say, by way of disclosure, I've consulted with both plaintiffs and defendants on nascent competition questions, and I'm also assisting the Attorney General of Colorado in their antitrust case against Google, in case Google turns out to come up. But for avoidance of doubt, today I'm speaking only for myself. Let me back up just a little bit, if I can, and it touches on some of what John was saying. Let me explain a little bit about what I think we should be focused on when we're talking about nascent competitors and how that overlaps, but not perfectly, with potential competition, and then talk through some of the conceptual and legal consequences from that, because that tees up how to think about framing up a case as an enforcer or as a private party, I suppose. And as you said, this draws on some work, some solo-authored work, but more recently some co-authored work with Tim Wu. We got a paper in University of Pennsylvania Law Review on this topic. So first, by way of definition, what we have in mind is a little different. It overlaps with, but it might be distinct from what has traditionally been thought of as potential competition. We have in mind a firm whose prospective innovation represents a serious future threat to the incumbent, and that's got a couple of pieces to it. One is that the nascent competitor is an innovator. Now, this matters because protecting such a firm, protecting the competition that flows from such a firm might be particularly important. I'm not saying only innovators count, but we're focused on innovators to kind of focus the issue a little bit. Second, the threats in the future. Things are in flux. Picking up on John's comment, it's often far from clear whether competition actually would have resulted. So I think we have to confront that squarely. And then the question is, what do we do with that, right? Let's grant for a minute a set of facts where one cannot say that it is more than 50% likely that there was going to be competition. We don't know. Maybe it's 20%, maybe it's 30%. Maybe there is a significant percentage, but we don't know how big it is. Is that going to be a deal killer, or a challenge killer, let's say? And I think that tees up maybe a point of disagreement among some of us. And third, a threat to an incumbent. So we're imagining situations where a powerful firm has a motive and an opportunity perhaps to neutralize the threat. So I think distinguishing this from potential competition cases, partly it's that there's innovation at stake. That might be true of some potential competition cases, but it's not distinctive of them. I think another point of distinction is that things are moving quickly. So this is not like your kind of run-of-the-mill product extension. Is the bank going to go into a new state? Is the outboard motor company going to enter the US? Is beer going to get marketed in a place where it wasn't marketed before? I think in these other more familiar contexts, the absence of entry thus far, it could be informative. If they haven't done it now, they probably aren't going to. And so, whatever one thinks of this existing pretty stringent potential competition law that's been elaborated principally in lower courts, what's going on here, I think, is a little different, and that policy and law, it makes sense, would pay attention to that different factual setting. Now, legally, turning to how I would frame up a case, in principle, this could be brought either as an unlawful maintenance of monopoly under Section 2, for which I think Microsoft gives us a pretty helpful recipe. I tee that up because we may have some disagreement on that, or as an unlawful merger under the Clayton Act. Now, for me, I think unlawful maintenance of monopoly is a particularly natural fit for some of these, given the fundamental nature of the issue. Efforts by a firm with monopoly power to neutralize, competition. But I think the Clayton Act could be available alternatively. Partly, I think the question about what positive law consists of here is it's a rich question for us to explore. I hate this term, actual potential competition. APC, I'll say case law, as developed by lower courts, has been hostile. We see this in cases like Steris, which I think probably people on this call have in mind. I would say that the legal treatment of these cases ought to differ, at least the ones that raise nascent competition issues, for reasons we were just sort of talking about a little bit. The last point, and I'll stop. And this is sort of trying to confront the issue that we may not know what would happen, or we may think there was a substantial threat, but we can't say with confidence that they would have entered and would have been successful. These are still harms that are very large in expected value, or can be. That even if the probability is modest, the face value is really high. And so you multiply those two things together. I think this is not very fancy economics. The expected value could still be really large. I don't think the answer here is complete non-enforcement. I think enforcers, you have to be ready to bring these kinds of cases. And I think, we see examples where that's happening.
Thanks, Scott. And, just to build off of that, I'll turn to Julie. Julie, do we need to change the burdens that we have or reshuffle it as compared to a standard merger when we're assessing nascent and potential threats? And given the harms that Scott mentioned, that they could be quite large, what's your view on that?
Thanks, John. Glad to be here on this esteemed panel with folks whose writing I have enjoyed reading over the years. Really excited to be here. I think that no, burdens don't need to be reshuffled. And one question that I ask when I think about this topic is, why should parties to a deal that will have a smaller near-term impact on market share and market concentration than a standard merger be required to meet a higher standard than parties whose standard merger will by definition have a larger impact on market share and market concentration, at least in the immediate term? Now, of course, theoretically, an acquisition of a nascent competitor could have a larger impact in the long term, but that's extremely speculative. And as we all know, agencies do have the ability to challenge mergers after the fact. They also have the ability to bring Section 2 cases, Section 1 cases, conduct cases later. And I think that the risk of getting it wrong ex ante is just extremely high. Acquisitions are an exit strategy for a lot of investors in small firms. And changing up burdens may make it more difficult for smaller firms to scale up to do R&D, for example. And really, I don't think we've pushed the limits of our existing laws right now. I mean, the nascent competition theory of harm, at least in the merger context, is still largely untested. Agencies have alleged that type of theory, but in most of the cases where they've done so, the parties have abandoned the deal. Visa Plaid being an example, Billy, Procter & Gamble, Edgewell Harry's, Illumina Pacifica, and Sabre Fairlogics, which is a case that I tried 2 years ago now while I was at the DOJ, is one of the few cases where it has been tested in the merger context. Now, obviously, it did not go well for the government, but I don't think that that's because burdens in nascent competition cases need to be reshuffled. I think the real problem in the Sabre case, or the main issue, was the court's misapplication of the Supreme Court's opinion in Ohio versus American Express, and then the Second Circuit's opinion in US Airways versus Sabre. These were two higher court decisions that had come out. The latter of them came out right around the time the government filed its complaint. And so this two-sided market issue, and whether or not a one-sided competitor like Faralogix could be a competitive constraint on Sabre, a two-sided competitor really was at the heart of the government's loss there. You know, and I think one of the problems with shuffling burdens is that the proposals for doing so don't define very well, you know, which cases should be subject to this burden shift. You know, some of the proposals propose shuffling burdens depending on the identity of the acquiring party, the size of the acquiring party. They'll say, well, where the acquiring party is a dominant platform, or where there are network effects, you know, that's when we should shuffle the burdens. But these terms are squishy, they're undefined, and they change over the time. Whether a particular firm falls within the definition of that may change over time. And so it injects this whole level of uncertainty to both enforcement and to deal making. You know, the so-called dominant firms today, they're not the same as the dominant firms 30 years ago. And, you know, it's interesting to imagine if a standard like this had been applied back then. So I think, you know, in terms of nascent competition, I think the government just needs to do a better job of selecting the cases it decides to take to trial when it's advancing a more novel theory, like the nascent competition theory. And there are a number of things that they can do. You know, obviously make sure that they have the personnel that they need to effectively litigate and try the case. Make sure that they have ordinary course documents that show that the nascent competitor is viewed as a competitive threat, and that the intent of the acquisition is to stamp out competition. You know, I actually think the government did have that type of evidence in the Sabre case. Make sure that there are fact witnesses who can support that theory of harm, ideally both third-party customers as well as corporate executives, the party's own executives on adverse direct. Again, I think this evidence was present in the Sabre case as well. And gather the best economic evidence. And in the Sabre case, the economic evidence was weak. And, you know, I think also too, just taking extraneous factors, whether it be, you know, political motivation, emotion, take those kinds of extraneous factors out of selecting the case to bring. And I think just unfortunately for the government, Sabre just wasn't the best case to test a nascent competition theory. And there are a number of reasons for this. One of them is that there were two other full service, two-sided platforms competing in that market with Sabre, two other global distribution systems. And so with those present there on both sides of that alleged two-sided market, Section 2 was not available as an additional theory of harm. The DOJ was limited to the Clayton Act, Section 7. As I mentioned earlier, the release of that US Airways versus Sabre opinion right around the time the government filed the complaint was also problematic. That case took Ohio versus Amex and overconstrued it to say, as a matter of law, that a two-sided platform, that is always the case, that only a two-sided platform can compete against another two-sided platform. And I think when you're talking about a merger, where we all know that market definition is an intrinsically fact-intensive inquiry, I just don't think that a statement like that is correct. And unfortunately, at the time, the DOJ political leadership just didn't feel comfortable, you know, confronting those two cases head on. And so, and whether or not they applied to a merger case. You know, you look at Brown Shoe, which makes clear that market definition is a fact-intensive inquiry, and that the area of competition, or the definition of relevant market, should be where competition in fact exists, the overlap between the two parties. But I think that the government's not unwillingness to sort of take that head on at the time did limit the team somewhat. And so we may see some of the agencies taking those types of opinions head on. But I just think that right now we haven't really seen how far our existing law can take us if we have the right nascent competition case to test.
Thank you, Julie. And you mentioned economic evidence, and that's, I think, obviously very critical to almost all antitrust cases. And so turning to Jeff, can you briefly describe the economic theories supporting a heightened concern about nascent and potential competitor mergers, and how robust are those theories in your view?
Sure. Thanks, John. And like everyone else, I'm delighted to be on this panel with friends and colleagues that I respect and always learn from. On your question, John, I think I tried to sort of write down a couple of ideas from what people said before me that I think, I doubt this is a complete list, but a couple of the elements that sort of suggest there should be heightened concern here. I think one is this, and I'm going to stick in many ways with your distinction between nascent and potential competition, and I'm really talking about what I think we call nascent competition here. The concern with innovation that Scott mentioned is, I think, important here. There's a sense that what we really want from the protection of competition, what antitrust is really supposed to deliver, is the innovation and consumer welfare benefits that can come from competition. And so to the extent that we're really focused, we're talking about how the merger activity of an incumbent firm can impede that kind of innovation. There's a sort of a heightened concern. I think there's a sense that the potential harms, I think Scott said this with his point about the sort of simplistic math at the end, but that the potential harms are dramatically larger. I don't think he said it this way, Scott, but than the potential benefits. And so there's a sort of standard error cost approach would suggest that we should be concerned here that the cost of false positives isn't going to be so large. And I'm going to add to that another aspect of the theory here that is not so much an economic theory, but I don't know, a factor that comes in here that's of, I think, particular importance and certainly of particular salience to me, which is this notion that intent matters, that everyone understands that we're dealing with dramatic uncertainty here. Not only do we not know the counterfactual, but we don't know two counterfactuals. We don't know the future with the merger, nor do we know the future without the merger. There's a really large degree of uncertainty here. So we're always going to be looking for proxies to try to solve that problem, and intent seems to come into this one a lot, and more so than it would in normal sort of antitrust. So a couple of things I want to say here in response to these. I think the first thing I want to point to is a kind of lack of symmetry with standard merger analysis, and it comes in a kind of weird way. I think the right parallel is not between a nascent competitor merger and a traditional potential competitor merger, but the way that the kind of potential competition idea comes in my mind, in the relevant sense, in normal merger analysis, is in the market definition and entry barriers questions. In other words, in some ways, the notion of potential competition in traditional merger analysis is a potentially pro-defendant notion. It is the idea that and these are really weak in traditional merger analysis, I should say. But the idea that a supplier could substitute a current supplier could shift into production in the relevant market and become a potential competitor, that could suggest the market definition is broader than assumed, or that the number of competitors is broader than assumed. I think entry barriers are really crucial to this. What we're really talking about here is conduct by an incumbent that precludes future competition it's largely the same sort of analysis you have in an entry barrier analysis. Those are, in sort of traditional merger contexts, really weak proxies for potentiality. They don't look at very often at very specific the viability of a particular competitor. It looks at superficial, sort of structural issues, and it's generally kind of non-quantitative determination. Barriers are significant here, or enough, or likely. I mean, all these, sort of weasel words that we're used to. The reason I think this is important is because in the context of the nascent competitor merger challenges, it sort of gets flipped on its head, and there's a sense that all of those uncertainties are sufficient to justify stopping a transaction today, even though they would never allow a transaction in the more traditional context. And I think the best way to see this is something that John Yun has raised a couple of times. The idea that when Facebook buys Instagram, you're suggesting that Instagram is a potential competitor, but not considering that Snapchat, TikTok, Twitter, and Pinterest and 100 others are also potential competitors. There's I don't know what the right word for it is, but there's the focus is biased on the company that is being acquired. And the ironic thing is that the logic that suggests that Instagram could be a potential competitor to Facebook is exactly the same logic that should suggest that Snapchat, TikTok, Twitter, and everyone else are potential competitors as well, which should dramatically mitigate the expected harm from a purchase of a single one of these potential competitors. What in my mind it comes down to is a sort of confusion between the idea that removing a potential competitor, between the ideas of removing a potential competitor and removing potential competition. And the removal of a single potential competitor without, I mean, there may be specific instances in which this is not true, in which it's very clear that that is tantamount to the removal of any kind of viable competition. But typically, the removal of a single competitor is not going to remove all competition. I think some would respond to that by saying, well, the fact that Facebook focuses on Instagram, for example, suggests that it thinks that it is indeed the most significant competitor and the one that really could mount a challenge, and we would be right to focus on that. I think in many ways this is the sort of intent argument, and I think it doesn't really work unless you assume the thing you're trying to prove, that the only reason Facebook would want to buy Instagram is to buy out, is to remove the threat of competition. But you can't assume that. You're trying to demonstrate that. The fact that it wants to do that, of course, is also not an indication that it will actually succeed in doing that, which goes to my point that there are many other sources of potential competition. I know that I'm out of time, but I have one thing I have to flag that I'll do very quickly, and just because I think it should come up in the future conversations, and that is to say, a lot of this is really undergirded by this notion that that we should be more concerned here because the classic formulation of this is monopoly profits are greater than duopoly profits. The incumbent protecting its monopoly position will always spend more than anyone else to protect its monopoly than a new entrant will to try to be a competitor with the existing monopolist. It's an assumption that I think undergirds all of the analysis we have in this space, and I think it's wrong. So I don't have time to go into why it's wrong right now. I hope we'll get a chance to talk about it later, but I think we should really consider the fact that the assumption that or the notion that the incumbent may have an incentive to impede competition should not be deemed sufficient to assume that it is in fact accomplishing that when it buys out something we could identify as a potential competitor.
Thanks, Jeff. And Scott, Jeff mentioned your intent argument. I don't know if you wanted to follow up or you're happy to.
Yeah, sure. I'm happy to jump in with respect to that. And I guess a couple of things. One, this is an argument that Tim and I press in the article. I don't claim that as a huge point of novelty. I think there's a lot of people that have some of the same thoughts along these lines.
So let me, because you're here.
No. I'm not sure you even did. I'm happy to be associated with it. I just, I want as many fellow travelers given this hot bench as possible. I mean, I see among the attendees at least one or two that might agree with me, and a few more that would disagree. I think there's a couple of things to be said. One is this is a form of intent evidence, but I think as everybody, at least on our panel, knows, what we have in mind here is not let's kill them kind of evidence. It's more studious, here's my PowerPoint slide as Visa thinking about the threat posed by Plaid, right? With some clarity about what the motivation might be. So more of we describe it in the paper as an anti-competitive plan to try to narrow what it is that we're thinking about. It's not just some kind of emotional outburst or preference for winning or preference for an absence of competition, but a more reticulated understanding of what the market dynamics look like and what might serve to neutralize the threat. So think of the internet tidal wave memo of Bill Gates. And, I think this kind of evidence, there's another way of putting this too. Daniel Francis has a paper about monopolization who describes this as expectation evidence, which I thought was a very nice way of putting this idea that they expected an outcome of a certain kind. And this is a kind of economic evidence. It tells us something about what we think will happen. It's a kind of statement against interest by the parties involved. When we say in the paper something like, if they tell you who they are, that you should believe them. I think this kind of evidence plays a heightened role in contexts where we don't have scanner data. There's lots of situations, lots of mergers where, our kind of CSI effect approach to economic evidence sometimes seems just fine. Like the best evidence that's available is in the data, and we can fight about whether something's a natural experiment or what have you, but really finding it out on the econometrics makes a lot of sense. In other contexts, we don't have the data. The uncertainties are greater. These are actually two different points. And other kinds of evidence is going to, I think, necessarily play an outsized role. And we shouldn't have a one size fits all. And honestly, I think one consequence of that is to make enforcement difficult, even in situations where we might think that there's a there, that you still have to prove up your case. And so, if you don't have data and you don't have documents, and at some point you don't have the evidence that you need to prove your case. And so, partly our view that documentary evidence, that anti-competitive plan evidence might play a greater role in a case like Plaid Visa, for example, comes from the kind of recession of other kinds of evidence just because of the nature of the market or the other factual details of the particular intervention.
Thanks, Scott. And so, Jeff and Scott have been talking about sort of the ex ante evidence. And so, John, just turning to you, how about the ex post evidence? What would be the outcome, just taking Facebook, Instagram, that's something Jeff mentioned. What would be the right counterfactual? What are we looking for to say something was a good or bad acquisition from a welfare perspective? Can we even do that?
I think it's impossible and unknowable, and I think that's at the root of the problem. The cases under Section 7, I'll talk about Section 2 in a second, all say reasonable probability. And Scott makes a valuable point that if the potential harm is really, really great, do you want to force the government or the plaintiff to prove that entry and competitive impact were more likely than not, which is typically the standard under Section 7. And that's a very difficult standard to me. And so I would agree with Scott. I'm sure in individual cases we would differ, but I do think there needs to be some sort of sliding scale such that the greater the potential harm, the lower the burden on the government. I would still keep the burden pretty close to reasonable probability, but and I think that's where Scott and I differ. But there may be cases where the potential harm is so great that you want to have a lower standard. The reasonable probability standard makes these cases, whether you call them potential competition or nascent competition, difficult. But it also forces the government to really look at the facts and determine, is this outcome that we see in the future, so significant that we're going to, block a deal that may have some efficiencies associated with it to save that possibility. Talking specifically about some cases, let's talk about Facebook, Instagram. I think Jeff made an excellent point that there are a number of other social media companies out there. There is some evidence that Facebook sought to acquire Instagram to keep it away from Twitter. I'm not one that makes intent evidence universally dispositive, but I do agree that knowledge of intent helps predict facts and consequences. I think that's a phrase that I've bastardized from Justice Brandeis. And so I would not rule out intent evidence also, but I think it's important to be skeptical when using that as a basis to challenge a deal. Well, let me talk about Microsoft for a second, because it's bandied about in all these cases, in the DOJ case against Google, in the Colorado case that Scott is working on. It's raised in some of the other cases that have been recently filed. But Microsoft was a truly unusual circumstance. Netscape and Java were not about to become operating systems, but they could run applications on their platforms on any operating system. And that was the threat to Microsoft's monopoly. We're not seeing anything like that in these in the cases that are going on today. And this, unusual fact and the decision that resulted from it really should not be the be all and end all of our analyses of these deals, because that factual circumstance that your application, even though it won't compete with the monopolist, will form a basis for others to do so, just doesn't happen very often. I think you need to look for it if it might be out there, but I don't think it's a great policy to substantially change the law on potential competitor acquisitions.
Thank you, John. And Julie, I want to come back to you. You mentioned your experience on Sabre Fair Logic, and you literally were on the front lines. And, my reading of the case, and you mentioned this, and it wasn't a pure nascent potential competition type of case, or at least that's not how it was framed, even if it was behind the scenes. How was the case brought in your view? Was it a nascent competition case, and did it come out, directly as that, or was there a reason why it was brought perhaps more as a traditional case?
Yeah, I think that Sabre was a nascent competition case. Clearly wasn't a potential competition case because Fairlogics was already in the market and it was already competing with Sabre. One could debate whether or not Fairlogics was nascent or not, because it had been in the market for some time. And the reason why it was not bigger at the moment that the case was brought, according to the allegations in the complaint, is because of some of the tactics that Sabre had engaged in to keep it that way. And, I think if you look at the complaint, the first line of the complaint is Sabre's proposed acquisition of Fairlogics is a dominant firm's attempt to eliminate a disruptive competitor after years of trying to stamp it out. I mean, to me, that sounds a lot like a nascent competition case. And in fact, the DOJ described it that way in its press release relating to the abandonment of the Visa Plaid merger in January of 2021. So they're certainly owning it that way today. I think that that's a case where if Section 2 had been available to the government to use as a theory of harm, things would have turned out much, much differently. Because the government presented evidence at trial that Faralogics had complained about Saber's actions to various government officials, from the DOT to the DOJ to the European Commission, as recently as a year before the case was filed, about the different tactics that Saber was engaged in to try to stamp Faralogics out. Faralogics used to have a seminar every year called Disrupt. And really, the reason that Saber became so interested in purchasing Faralogics, according to the ordinary course documents that were presented at trial, is because one of Faralogics's innovations, called New Distribution Capability, or NDC, was something that was becoming the industry standard and was really taking off, particularly among airlines in other parts of the world, but increasingly in the United States as well. And it was at that point that Saber realized that its outdated technology was going to start falling behind, and it was trying to develop technology to compete with Faralogics's NDC, but it just wasn't as good. So, I mean, that intent type of evidence, that sort of plan type of evidence, that was all stuff that was presented at trial. And I think if Section 2 had been available as a theory, and we weren't having to sort of shoehorn that into your Section 7 analysis with HHIs, that it might have gone better for the government. Now, obviously, Faralogics's overlap with Saber was not complete. It offered only a subset of the services that Saber offered. But, as we all know, it's well settled that competitive overlap need not be complete in order for a merger to harm competition. I litigated another case also in Delaware, US versus Energy Solutions, where the same argument had been made by the defendants, and the court held that the merger was anti-competitive, even though the overlap was only in one part of the set of services that the acquiring firm offered. So, I certainly think of Saber as a nascent competition case. Like I said, one can argue about, the definition, how long a firm is in the market. Is it less than 5 years, 5 to 10? One can debate that. But I certainly think that when the acquiring firm is taking steps to actually keep that target sort of consigned to a little corner of the market, that's something that needs to be taken into account.
Thanks, Julie. Jeff, I think some of the calls for tougher standards and burdens, which Julie alluded to earlier, as well as, greater scrutiny by the agencies, is based off of sort of past acquisitions, including what has been mentioned, Facebook, Instagram, but there's also Google DoubleClick, Google Waze, although that might be a straight competition type of case, Google YouTube. What's your view on the empirical evidence of potential nascent competitor acquisitions? And, is there a justification for increased scrutiny or maybe even changing burdens?
No, but I say that with the clear recognition that I'm not sure we could ever have that evidence in any kind of reliable way. Again, as I mentioned before, you're dealing with two counterfactuals, at least one of which is never going to come to pass, and there's huge danger looking ex post at consequences following a merger that wasn't stopped and trying to infer anything about what would have happened had it been stopped. We see this a lot with the Facebook, Instagram discussion, and I think there's plenty of people on sort of both sides of this conversation out there. It's those who suggest that Instagram's success as part of Facebook was some indication that it would have been successful if it weren't part of Facebook have no evidence for that, of course. How could they? there's every reason to think that Instagram's success as part of Facebook was a function of being part of Facebook. And I think it's virtually impossible to determine that it would have had the same success if it weren't. There's some things that you can look at, like what's happened to other companies that weren't purchased seems somewhat relevant here. What's happened with TikTok? Well, it's become the most popular site on the internet. Facebook's fortunes have obviously fallen in the last couple of weeks, so hard to infer much from that kind of snapshot evidence, but it is, I think, relevant to note that competitors of Facebook's who may have been, in theory, harmed by Facebook's purchase of Instagram seem to be doing pretty well. Could they have done better? Of course, who knows? I mean, so there's a dramatic problem here with any kind of inferring anything about the evidence. What I think is really problematic, though, of course, is that there's a kind of thumb on the scale against recognition of the benefits of these kinds of mergers. And we've seen some of those benefits, right? Like, we don't know whether Instagram could have been better or even maybe displaced Facebook, but we do know that Facebook was made better by Instagram. That Instagram's technology, which was, or its specific product, which was used by, I think it was like 100 million people before Facebook bought it, is now accessed by billions of people. And if nothing else, the incorporation of some novel, new, innovative technology, I'm not saying that's the case with Instagram, but let's go with that for the moment. Incorporation of that into a dominant incumbent immediately spreads that technology or that innovation to everyone who is sort of, by definition, to the most people, because we're talking about the dominant company doing that. There's, in other words, some sort of obvious benefits that I think are too significantly discounted. But for the same reason that I said before, we certainly can't know that those benefits outweigh the potential harms, but we shouldn't discount them to zero, certainly.
Thanks, Jeff. And we're nearing the end here, so I just have a few more questions left for the panelists, and then I wish we had more time to hear your full thoughts on these issues. But Scott, let me turn to you and ask, from your perspective, in dealing with nascent and potential acquisitions, what's worse? Where's the bigger error? Falsely stopping a pro-competitive merger or falsely allowing and permitting an anti-competitive one in this space? What's your view on that?
Didn't I just tell you can't answer that question?
Yeah, it's got a kind of Zen koan riddle, it reminds me of Justice Scalia complaining about being forced to compare like the weight of a rock and the size of a feather, or I forget, like length against weight, or incommensurables, unknowables. I mean, clearly either of these can be problematic, right? Either a false condemnation or a false acquittal. I try to take us where we are right now. I think right now, the evidence of false condemnations in the context of acquisitions of nascent competitors, I think that's pretty thin on the ground. I mean, perhaps that's happened. I've struggled to think of one right now. Our level of enforcement against these has been pretty low. And so, in an error cost evaluation, the optimal amount of enforcement is, I think non-zero. Now, I understand that doesn't fully answer, right? If you have a non-zero amount of enforcement and you pick the wrong targets, that could be a big issue. And so, my statement that it should be non-zero won't satisfy Jeff by itself. For me, I think the risk of non-enforcement or under-enforcement is pretty vivid and urgent. And I'm sort of confirmed in this in an odd way by the headwinds that I see agencies being confronted with by, variations on the point that John made about how Microsoft is a singleton and is unusual because the threat was so great. And the threat was also odd in the sense that it would facilitate competitors rather than being a competitor itself. or I hear tell that because no pro-competitive justifications were recognized by the court. False on the DC Circuit opinion itself. John isn't saying that, and I think he's right not to, because that's not true. This kind of speed bump, I worry, is going to make agencies more reluctant than they ought to be to take on the basic logic of Microsoft, which is also reflected in cases like Activists, that harms need not be certain or even highly likely to be worthy of concern. And I understand John to be agreeing with that basic point, though again we may disagree about exactly what that should look like.
Thanks, Scott. And I'll actually turn to John. John, I don't know if you had any follow-up thoughts to what Scott mentioned, but one of the sort of costs of a false positive is the chilling effect on perhaps on startups and their exit strategy. And I know it's a commonly stated point, but I still think it's quite important. And so I don't know if you had any thoughts on that.
Wilson Sonsini typically represents the B side in these deals. We do a number of A side deals as well, including some big ones. But typically we're representing former startups that are looking to get acquired by larger firms. And so much of the investment in Silicon Valley is based on precisely that principle. I mean, who wants to invest to compete against Facebook? Pretty much no one. Who wants to invest to develop a capability that Facebook might find attractive and pay zillions of dollars for? Everyone. So, I think we need to have some concerns about the impact on pro-competitive startup investment of a stringent rule against acquisitions of nascent or potential competitors. To date, that has not been a problem, but in terms of the policies that appear to be being pursued by the federal agencies, as well as many of the states, this has to be a concern, and it's certainly a concern I have.
Thanks, John. And Julie, given your prior answer, I probably have a good sense of what your thoughts are on this, but there are calls to bring legislation in. Is there some areas, whether it might not be burdened, but some legislative help in this area that could really boost either the courts or the agencies in bringing these cases, the good ones?
I'm just not convinced that that's needed right now. I don't think that the case has been made for that. I read the House report that was issued in 2020 and some of the competing reports. And, a lot of the background focuses on losses like the loss that I had in Sabre. And I think in that situation, the government needs to be careful about the cases that it chooses to bring if it wants to advance a new theory of harm, or maybe revisit a theory like the vertical merger case. AT&T, was that the best vertical merger case to bring? Were there better ones to bring to make better case law? Was Sabre the best nascent competition case to bring? Or was it better to bring Visa Plaid, where you also had the Section 2 element? But I think the government, that said, the government's win percentage is still very high. And if it's not losing some cases, then it's not using the full potential of the laws that we do have. And if you look at the nascent competition cases, for example, that have been filed under our existing laws, I think they're still having a deterrent effect. You look at the deals that have been abandoned without the government even needing to go to trial just in the last year or two. You have Visa Plaid, Billy P&G, Illumina Pacific Bio, Edgewell Harry's. And I think the agencies have made clear that they're going to be taking a hard look at acquisitions of nascent competitors. That's expensive, these lengthy merger investigations. And I think that alone, the threat of a costly, lengthy merger investigation, is often enough to deter a transaction that, as Bill Baer would say, should never have left the boardroom. So I think, the solution certainly to some of these cases that the government has lost recently is not to make changes to laws that could have unforeseen ripple effects throughout our economy.
Thanks, Julian. Before I turn to Jeff, John, you have your hand up?
Yeah, so changing the antitrust laws is fraught with danger. And we've had a solid consensus, I would say, from the Kodak decision in 1992 up through the 2016 election on a consumer welfare standard that really helped the interpretation of the Sherman Act as well as the Clayton Act. We now see efforts to go and trash that standard and change the laws in a way that would change that standard. This is very dangerous stuff. It could be extremely damaging to the economy. We've got very good antitrust laws, so good that they have been the source of copying and adoption by most of the rest of the world. Well, let's not tinker with something that works really well and that has worked well for a long period of time.
Thanks, John. Jeff, we have a couple more minutes left, but I did want to ask you, if there's not enough time, too much, but John mentioned the US and exporting our stuff. The UK has brought a Facebook Giphy case, and can you just give a brief sense of where that is and if that has any chance of going anywhere?
Where that is, the most important thing to note about where it is that an Austrian court actually looked at that case and cleared the merger with some conditions, primarily relating to access to content for, I think, 5 years or something like that. I think Facebook Giphy is a great example of sort of overextension of the kind of concerns here. It's hard to imagine any sense in which Giphy was ever going to be a viable competitor to Facebook. And by the way, the UK's complaint against them was 300 pages long, so there's a lot of different theories in there. But Giphy has not been able to monetize. It is sort of ineffective at what it does in the sort of relevant market sense, but it provides a lot of interesting content that happens to be trivial to copy and implement elsewhere. The only thing that would sort of set a Giphy apart from a Google search for GIFs on the internet is the prospect that it has some kind of a mechanism that enables making use of these GIFs in a really important way, particularly for advertisers. But the UK mentioned search a lot, but I don't really think Giphy's search for GIFs is any better than Google search. So it really comes down to monetizing the advertising on it, and that's just a sort of a pathetic claim here, in all honesty. Now, Facebook is challenging this. I think there's a hearing actually soon on this. Who knows what will happen? But I would also like to point out, just relevant to what John was just saying, that at the time of the challenge, Giphy, before Facebook bought Giphy, Giphy earned no revenue whatsoever in the UK, and the entire thing fell well below EU thresholds. It probably should have fallen below UK thresholds, except that they have a weird mechanism that allows them to look at these sorts of cases. So you do have this interesting issue of a completely foreign entity taking on a sort of purely US merger with arguably insufficient contacts to the place where it was being challenged. And it's a terrible case.
Thank you, Jeff. Thank you, John. Thank you, Julie, and thank you, Scott. Thank you very much to our panelists for a terrific conversation. That concludes our session. Please return at 9 a.m. Eastern tomorrow for a full day of programming, including 4 panels and a keynote from Bill Kovacic, and you certainly don't want to miss that. So thanks, everybody.
Thanks so much.
And everyone else.